So the organization that Lizzie and I are with is called For the People. We're a national, nonpartisan, nonprofit organization. And in 2018, our founder and executive director, Hillary Blount, really conceptualized, drafted, and then helped pass the nation's first prosecutor-initiated resentencing law. And this is a law that allows prosecutors to look back at past sentences and then allows them to recommend resentencing where it's shown that a person can be safely released. We really began, or she rather, began implementing the first PIR law in one California county. And now we're working in several states, across several jurisdictions across the country to enact legislation, to implement resentencing initiatives and units within prosecuting agencies, and then to support the successful reentry of people that are released from prison. So one thing that I wanted to do was share this quote from the American Bar Association. I think it's a really powerful way to set the tone for why it is we do this work day in and day out. So as you all very well know from the work that you do, prosecutors aren't just mere case processors, taking in a case, processing it, and then being done with it. They really are problem solvers. And as a former prosecutor myself, I fully believe in this idea that prosecutors uphold the broader goals of the criminal justice system. So as a result of that, those duties don't merely end at the time of sentencing because we're not just case processors, we're looking at the system as a whole. And because of the role in the system that prosecutors really play, there's an ongoing responsibility to reform and improve the administration of justice when it's inadequate or unjust through the means of remedial action. So, with that principle in line, the American Bar Association adopted PIR as a resolution just last year. And that's a really powerful way for the ABA to incorporate innovations from the legal field into its policies, signaling that there is a support for this notion to be incorporated into more and more prosecutors' offices around the country. And the resolution itself, as you can see here, urges governments to enact PIR laws, signaling the need for prosecutors to lead some of those changes that are really essential in the justice system. So I'm going to kind of start as to where our organization started, because it's really important to acknowledge that the concept of looking back wasn't new to our organization's work. Obviously, a lot of the work that you all may do or your offices may be involved in involves conviction integrity work to really address wrongful convictions. And these units seek to address whether a person was factually innocent or if there was a due process violation. And as we were talking to more offices, the one striking thing that really emerged in these conversations was that offices were getting requests for cases where it wasn't necessarily the result of a wrongful conviction. The person had, in fact, committed the crime, but they were seeing more and more requests where the sentence was based on some kind of outdated policy where a prosecutor would never recommend a sentence to that amount or just simply would not be allowed to because sentencing guidelines had changed. Or the person had significantly rehabilitated during their time in prison. And as a result, the number of those cases started to really outweigh the number of wrongful convictions that offices were seeing. But at the same time, there wasn't a legal vehicle for prosecutors to undo a sentence because it was too long or because a person could be safely released. So, taking the prosecutor's perspective into account, we really started to look at people who were serving time in prison. And Lizzie will go into more detail about that a little bit later. But in reviewing the data, looking at the prison populations, some real themes started emerging about, who should be going to prison, who is actually in prison, how long should they be serving, and then who currently still is in our prisons how are they doing, and then can they be safely released? So as a result, lawmakers, community organizers, academia, practitioners, and then prosecutors really began thinking about and sort of grappling with these questions and these themes, which served as a really important backdrop to why prosecutor-initiated resentencing came to be. So, with these factors sort of serving as a backdrop as to why prosecutors are motivated to look back at old sentences, and through many of the conversations that Hillary, our executive director and founder, was having with various stakeholders, she actually worked with the bill sponsor, who was a district attorney who was looking to fix some outdated and unjust sentences for a while, and realizing that a narrowly tailored reform where prosecutors are in the driver's seat and they have the ability to balance public safety and the engagement of victims while having the resources and tools to do it right, that was really essential to the passage of the law. It had to sort of go hand in hand. And that's really where the inception of our organization started. So after working with so many stakeholders and helping pass the law, she knew that there were going to be a lot of questions about how the law works. That's where For the People was founded to help prosecutors with the implementation, to sort of fill the gap between an office genuinely being interested in this work, but not really knowing where to start, and helping to lighten the initial load of launching a unit or work such as sentencing review. And interestingly enough, the name For the People really came from Hillary's days as an assistant district attorney when she was standing up in court, introducing herself and who she represented, hence For the People. So it was really important to position the organization as one that was nonpartisan and non-advocacy based, meaning we work with prosecutors who represent constituents along the political spectrum. As long as those offices are really aligned with the goal that they want to review past sentences and see if people are potentially eligible for earlier release. And we're a technical assistance provider, meaning we create processes for prosecutors to eventually incorporate this into the culture of their office and have the tools to do this work independent of our organization. And so just to sort of clarify exactly what that means, we don't advocate for cases, but instead we collect, synthesize, and provide all information available about an incarcerated person to prosecutors, work with a diverse set of stakeholders that Lizzie will go into a little bit more, so they can decide the best way to proceed with a case. And after California passed its law in 2018, we saw 4 states pass its own PIR law, that being Washington, Oregon, Illinois, and then most recently, Minnesota. So we have 5 states with PIR laws, as well as many states that have alternative legal mechanisms to be able to go back and address long and lengthy sentences where there may not be retroactive mechanisms in place for the actual offense. There are alternative legal mechanisms that are available. We've seen that it's a bipartisan movement. Places from as different as Texas to Massachusetts, from Maryland to Florida, from Georgia to Utah have introduced PIR bills, which I think really hones in on this idea that it can really be something that people of both parts of the political spectrum can agree is an essential part of reform. And we have 34 prosecuting agencies and growing. We've already included a number of new agencies into this work, growing across the country, who are taking on PIR, and over 850 people that have been released nationally as a result of this mechanism. So just real quick before I turn it over to Tammy, here's how the PIR law works. So first off, the PIR law gives prosecutors complete discretion as to whether or not they'll review or recommend a case for resentencing. They're not required to do so. They can choose whether to take on the process in their office. And we realize prosecutorial discretion was a really essential piece. Prosecutors need to decide for themselves, for their office, and for their community whether or not they want to take on a case for purposes of resentencing. There are no mandates. There are no types of cases that prosecutors have to review. And there really are no carve-outs, minus a few very, very limited exceptions, excluding the certain categories of cases that prosecutors cannot review. So they get to really decide what is appropriate for a review, how many cases, what is the pace in which they would like to review cases based on the needs of, as I mentioned before, their office and their community. Tammy is going to touch on this a little bit more during her piece, but victims are engaged and consulted during the evaluation process, and prosecutors really weigh the opinion of victims in making that determination. This was essential to the passage of that first law because we heard from prosecutors that balance of public safety and the weighing of victims' opinions is essential. So victims are afforded the same rights as they would be at the time of sentencing, meaning they have the right to attend the hearing, to make a statement, to make their opinion known, essentially, as to their position on resentencing. And defense attorneys and the community work with prosecutors to collect this helpful information, which really helps lighten the load on prosecutors. And we've really seen that it's a model that defies the adversarial typical relationship that many of us may be used to with defense attorneys, in that motions are usually drafted collaboratively and in unison, and both sides are oftentimes advocating on the same side at a resentencing hearing, and there are very few disagreements, if any, at the time of resentencing. Ultimately, the law provides courts with the jurisdiction to decide whether or not to grant the recommendation from the prosecutor. So the prosecutor files the motion, but ultimately the court has the power to weigh that motion and be the ultimate arbitrator of that decision. And the court can sentence a person to a new sentence that's less than the original sentence, so long as it's legal. And the court cannot the court can sentence a person in a variety of ways. It can result in the person being released right away, eligible for a sooner parole hearing, or resentenced to a less time, but still with some time remaining on their sentence.